So today we're going to continue our discussion on the deeds of conveyance. And in our previous talk, we established the fundamental requirements for a valid deed and we explored the six deed covenants. And today we're going to build on that foundation by examining the different types of deeds that are commonly used in Georgia and by looking at the format of deeds, which is critical for their validity and their recordability. So let's start with the most robust form of deeds, and this is the general warranty deeds. They're also commonly known as just warranty deeds. So these provide the highest level of protection for the grantee, which is the buyer, because it contains a general warranty covering all of the deed covenants that we've discussed previously. And this puts the grantor or the seller on the hook to defend the grantee's title against all claims of any person's, whomever, doesn't matter. And the language is typically found in a general warranty deed that embodies this promise. It says, and the said grantor will warrant and forever defend the right and title to the above described property unto the said grantee against the claims of all persons whomsoever. So the key takeaway here is that the scope of the grantor's deed covenants are not limited to the time that the grantor owned the property only. So that means that if a title defect arises from a period that's before the current grantor owned the property, maybe there's like an unpaid lien from a previous owner or something like that, then the current grantor, the one who gave the general warranty deed, is obligated to defend the grantee's title against that claim. So this is a comprehensive protection, and it's why the general warranty deeds are the most commonly used in real estate sales in Georgia. Buyers basically will demand this level of assurance. Okay. So let's say that you have, I don't know, Sarah, who sells her house to John with a general warranty deed. Well, 5 years later, let's say that there is a tax lien from a previous owner who sold the property 20 years ago that surfaces. So this lien creates a cloud on John's title. So under the general warranty deed, Sarah is going to be obligated to defend John's title against this claim, even though she had nothing to do with that original lien. Okay. If she can't clear it, then she may be liable to John for any damages that are caused by the lien. Next, we have the limited warranty deeds, and these are also known as special warranty deeds in some states. And a limited warranty deed contains a more restricted warranty compared to the general. It covers all of the deed covenants, but it only puts the grantor on the hook to defend the grantee's title for issues that arise from things that happen during the grantor's watch, basically meaning while they own the property. So the typical language reflecting this limitation is, and the said grantor will warrant and forever defend the right and title to the above described property against the claims of all persons owning, holding, or claiming by and through under said grantor. So notice the crucial phrase, by, through, and under said grantor. This limits the grantor's liability to only those title defects that they themselves caused or allowed to arise during their period of ownership. They are not warranting against any defects that existed before they acquired the property. Now, in Georgia, the limited warranty deeds are the most common type of deed used in commercial real estate conveyances. And why is this? Commercial transactions often involve more sophisticated parties who conduct extensive due diligence and title insurance. So the seller may be a developer or an investment firm that doesn't want to be liable for the entire historical chain of title, only for their period of ownership. So for example, let's just say that you have the ABC Corporation, right? And it sells a commercial property to the XYZ Corporation with a limited warranty deed. And let's say that 2 years later, a previously unknown lien, maybe it's an environmental lien or something, that's discovered that arose during the period before ABC Corporation owned the property. So under a limited warranty deed, ABC Corporation would generally not be liable for this lien because it didn't arise by, through, or under them. Okay. But if it arose during their ownership, like from their own activities, they would absolutely be liable. Now, the third type of major deed is the quitclaim deed, and this offers the least amount of protection for the grantee. It simply conveys whatever title the grantor possesses, if any. So it's not going to warrant that the title is actually valid, and it does not offer any kind of um, deed covenant. So essentially, a quitclaim deed says, whatever interest I have in this property, I'm giving to you, but I make no promises about whether I actually own it, whether it's good title, or whether there are any encumbrances. So the grantee takes the property as is with respect to the title. So the consideration recital in a quitclaim deed is typically stated for love and affection, especially in transfers between family members, or it'll have something like for nominal consideration, like $1 or $10. That highlights that these transfers are often not at arm's length like commercial transactions. These are commonly used in gifts or divorce settlements or some other type of intra family transfers. But they can also be used to clear clouds on titles where someone may have a questionable or minor interest that needs to be formally relinquished. Okay, they're rarely like the standard that's used in sales between unrelated parties because, again, they offer no protection to the buyer. So, for example, a husband who wants to transfer his interest in the marital home to his ex as part of the divorce settlement, he would use a quitclaim deed. And this will effectively remove his name from the title. But again, he's making no promises to the ex about the quality of the title or any kind of liens that might exist. And the ex has to accept those risks. Now, beyond these three main types, there are some other deeds of conveyance that are used for specific purposes. First is the executor's deed, and this deed conveys title out of the estate of a deceased person whose last will and testament was probated. So, an executor who's appointed by the probate court is going to use this deed to transfer the property according to the will. So, if John dies and his will leaves his, house to his daughter, then the executor of John's estate would sign an executor's deed to transfer the house from the estate of, say, John Doe to the daughter. Next is the administrator's deed, and this deed conveys title out of the estate of a deceased person who did not have a will probated, meaning they died intestate. So an administrator then is appointed by the probate court and they handle the distribution of the estate's assets, including real property. So let's say John dies without a will, and the court appoints an administrator to handle his assets. So the administrator would then use the administrator's deed to transfer John's property to his legal heirs according to the state laws for those who died intestate. Next is the trustee's deed, and this deed conveys title by a trustee under the terms of a trust. So the trustee holds legal title to property for the benefit of beneficiaries, and the trustee's power to convey is governed strictly by the trust agreement. So, for example, if you have property that's held, say, in the Smith Family Trust, right? When the trustee, according to the terms of the trust, sells the property, they would then sign a trustee's deed to transfer it from the Smith Family Trust, by, let's say, Jane Smith, the trustee, to the new buyer. Next is the guardian's deed, and this is going to convey title on behalf of a minor. So if a minor owns real property and it needs to be sold, then a court-appointed guardian typically is going to execute a guardian's deed, which is often going to require court approval for the sale. So if you have, say, a 12-year-old who inherits a piece of land, in order to sell that land, their legal guardian would sign the guardian's deed, but it would be after they obtained permission from the probate court. And finally, we have the corrective deed. And this deed fixes an error in a previous conveyance in the property's chain of title. And errors can include things like misspelling of names or, incorrect legal descriptions or missing signatures. And a corrective deed is used to clarify and rectify these mistakes without performing an entirely new transaction. So, for example, if you have a previous deed that misspelled the grantee's last name, then a corrective deed would be prepared. It would be signed by the original grantor or their heirs if that person has passed, stating that the correction and has happened and referencing the original deed. Okay. Now let's look at the format of deeds of conveyance. Regardless of the type of deed that you prepare, the underlying structure is largely the same. However, while there is absolutely no set format in Georgia, a deed does have to contain certain language and content in order for the deed to be valid. It also has to conform to any kind of spacing or margin requirements that are needed for recording. And of course, don't forget about the official and the unofficial witnesses that are required that we've discussed previously. But let's go through some of the common elements of a deeds format. First is the return instructions. This is typically located at the top of the first page, the top left specifically. And it's the address where the original deed should be returned after it's been recorded in the public records. And this is typically the closing attorney's office and will often also note the property's tax ID for any, clarity purposes. So, for example, it might say, return to ABC Corporation address, blah, 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 and then the tax ID for the property. Then it has the caption, and this is usually at the top right or the center of the page, and it indicates the county and the state where the deed was executed, which means signed, by the grantor. Now, importantly here is that the caption does not necessarily reflect the county and the state where the real property is located. So it might say like state of Georgia, county of Fulton, if it was signed in Fulton County, even if the property is in Cobb County. The next section is the preamble, and this contains the date of the deed and the identity of the grantor and the grantees. And it typically starts with this indenture made and entered into this, whatever day of whatever month and whatever year by and between. Now, if there are two or more grantees, this is a very crucial place to specify how they will hold title. Is it going to be tenants in common? Is it going to be joint tenants with the right of survivorship? Whatever it is. If the preamble is silent on this, then tenants in common will be presumed by law in Georgia. So, for example, it would say something like, by and between, say, John Smith, hereinafter, grantor, and Mary Jones and David Lee as joint tenants with right of survivorship, hereinafter grantee. Then it would have the granting clause, and this is the operative part of the deed that states the grantor's intent to convey. Now, in Georgia, it typically doesn't state the actual purchase price, but instead it has a recital of consideration. It's usually a nominal recital of consideration, which is the $1 or $10, followed by, any an other good and valuable consideration. Now, in quitclaim deeds, again, traditional monetary consideration is not required, and instead it's often with love and affection instead, particularly in transfers between family. So, for example, it might say, grantor for and in consideration of the sum of $10 and other good and valuable consideration in hand paid at and before the execution, sealing, and delivery of these presents. The receipt whereof is hereby acknowledged, has granted, bargained, sold, aliened, remissed, released, I'm trying to think of all of it, conveyed, confirmed, and by these presents does grant, bargain, sell, alien, whatever, unto the said grantee. Next is the legal description, and this is the exact description of the location and boundaries of the property, which we've talked about in another lecture, but it encompasses more than just the property street address. So deeds may also include limiting language to limit the scope of the grantor's warranty. And this is crucial, especially in those general warranty deeds, to acknowledge anything that would be a known encumbrance. Okay. So some sample limiting language would be like, this conveyance is made subject to all zoning ordinances, easements, and restrictions of record. And this means that there could possibly be an easement or something like that that's on the property, but the grantor isn't warranting against these known and disclosed items. Next is the habendum clause, and this clause typically begins with to have and to hold, and it indicates the type of estate being transferred, which is like fee simple, life estate, or whatever, and it often reiterates the grantee's method of holding title. So to have and to hold the said bargain premises unto the grantee, his heirs and assigns for forever in fee simple would be sample language there. Next, we have the warranty clause, and this section contains the grantor's promise to defend the grantee's interest per the deed covenants. So the scope of the warranty will be general, limited, or non-existent depending on the type of deed that gets executed. So like, for example, for the general warranty, it would say, and the grantor will warrant and forever defend the right entitled to the above described property unto the said grantee against all claims of all persons whomsoever. And finally, we have the testimonium. And this is the area of the deed where it is signed by the grantor. Now, as we know, the grantee does not sign the deed. The grantor's signature, though, must be witnessed by at least two witnesses, one of whom is going to be an official witness, like a notary public. And this section is often going to contain the language where it says, like, in witness whereof, that we've talked about in our previous section. Now, as you prepare and review deeds, remember a few critical points here. First is to leave a 3-inch margin at the top of the first page of any document that is sent for recording in the public records. That space is reserved for recording information by the clerk of Superior Court. And if you fail to do so, it can actually get your document rejected. You should also confirm the type of deed that's being used. And this is going to depend on the transaction's nature and the level of warranty that the grantor is willing and, let's just add, and legally able to provide. You should carefully proofread the legal description and all other parts of the deed, actually, when you prepare it, because even a small typo can cause some really significant problems. You want to make sure that you use the correct names of the parties. As we've discussed, the grantor's names have to match their vesting deeds, and then all parties should be, identified accurately. And then finally, if you have two or more grantees, you have to make sure that you are clear about how they want to take title: tenants in common, joint tenants with the right of survivorship. Okay. This is crucial for defining their ownership rights, especially when it comes to survivorship. Again, if left ambiguous, then the Georgia law is going to assume that it is tenants in common. Now, let's talk about just one more thing very quickly, and that is the typical provisions in a residential purchase and sale agreement. And as mentioned before, again, there's no single set format, but the forms like those are from the Georgia Association of Realtors. And they are widely used, and they contain the common boilerplate provisions alongside spaces for deal-specific provisions. So I do encourage you to review a sample of those, and you can see some of them, I think, in your textbook, but you can also find them online. And that's pretty much it. In our next segment, we're going to talk about the aspects of transfer tax and the process of recording deeds in the public records. I know it's so exciting. If you have any questions, reach out. Thanks. Bye.